So hi everyone, my name's Alex Hardy. I'm a lawyer and a publishing industry advisor, and I'm a member of the policy committee of the Association of Learned and Professional Society Publishers. I'm really pleased to be hosting the first ALPSP webinar in the Asia Pacific region. We've had nearly 200 registrations for today's event from publishing professionals all around the world. So for those of you whose time zones have permitted, thank you for joining in person. The webinar is being recorded and this will be made available to all the registrants as well as all ALPSP members. Before we begin, just note that your microphones have been muted. So if you have any technical issues, please just use the Teams chat function to let us know. And we will have a Q&A session after the speaker presentations. So you can also use the Teams chat function to send us any of your questions as we go along throughout the webinar. I'd like to begin with an acknowledgement of country. And for those outside of Australia, an acknowledgement of country is the customary way that we begin any meeting of significance. It's a way to show respect for and acknowledge the culture and heritage of the traditional owners of our lands, and it demonstrates their value within Australian society today. So I'm speaking to you today from Melbourne, close to the banks of the Yarra or Birrarung River. And this is the traditional land of the Wurundjeri people of the Kulin Nation. And I pay my respects to their traditional owners, past and present. Of course, we've got speakers and attendees joining us from around the world today. And something I hope we will keep in mind while we're listening to the presentations today is how our legal systems, including our copyright laws, and developments in technology such as generative AI, can be respectful and inclusive of Indigenous traditional cultural knowledge in many countries, including in Australia. But before we get stuck into the topic, I'd like to take a moment to introduce you to the ALPSP community. The Association of Learned and Professional Society Publishers is a trade organisation for the publishing community. And based in London, it has over 300 member organisations spread over 35 countries. Crucial to the work of the ALPSP is promoting best practice and sharing knowledge. And it does this through webinars and events, usually hosted in the UK and Europe and the US. As I mentioned, this is the first ALPSP webinar hosted outside those regions and reflects the organisation's strategy to engage with existing and new members across the Asia Pacific and to inform other members about scholarly practices in those regions. We are happy to have the Copyright Agency here in Australia as part of our ALPSP community. And we're extremely grateful to the agency for sponsoring and hosting today's event. The Copyright Agency has done a huge amount in the past year or more supporting its members and its stakeholders to learn more about generative AI and copyright. So I'm pleased to introduce the CEO, Jo Johnson, who can tell us a bit more about the agency and its work in this area.
Thank you, Alex, and welcome everyone. We are absolutely delighted to be supporting Alex and the team in hosting this webinar for AI and copyright. AI has been a core focus for the Copyright Agency over the last year or so. We acknowledge that there is a deep and genuine concern on the part of many of our members regarding the use of their work in training large language models offshore in other jurisdictions. Now, those models underpin the tools that are being deployed and used throughout Australia now. Together with others in the creative sector in Australia, we are advocating that the government intervenes and introduces a new mechanism to provide compensation for Australian rights holders when their work has been used in this way. But in addition to this, we want to play a part in the uptake of ethical AI in Australia. We want to do it in ways that align with supporting our creative industries. We firmly believe that the two things are entirely compatible: innovation and a sustainable creative sector. And we think that there is no trade-off required between the two. Australia has a strong and flexible copyright regime. Many AI activities are already permitted under our statutory licence schemes that support use within education and government sectors. In addition to those schemes, the Copyright Agency's first step is to extend our annual business licence so that it allows staff of licensed businesses to use third-party material as part of prompts for AI tools. We have new information about this on our website, but please feel free to reach out and contact us if you would like to learn more. It's an exciting time. And I'm very much looking forward to this discussion. Thank you very much, Alex. I'll hand back to you.
Thank you, Jo. It is an exciting time, that's for sure. Well, I'm speaking to you today as a member of the ALPSP's Policy Committee, and our committee aims to inform members about legal and policy developments affecting the scholarly publishing community. And we do this by providing briefings, policy bulletins, responding to government consultations. As you can imagine, we've had an incredibly busy 12 to 18 months considering proposals from governments all around the world. As they adapt various laws or consider adapting laws in response to developments in generative AI. The majority of this work has been focused on developments in UK, Europe and US, but of course the intersection of AI and copyright is currently under consideration in many other countries. So today we've got the chance to hear from members of the publishing community in the Asia Pacific region about approaches taken in their countries and how publishers are responding. So joining us from Singapore, we have Peter Schopert, Director of NUS Press, the scholarly publisher of the National University of Singapore. Peter is a former president of the Singapore Book Publishers Association and is a member of the Copyright Working Group of the International Publishers Association. From Australia, we have Dr. Stuart Glover, the Manager for Policy and Government Relations at the Australian Publishers Association. At the APA, Stuart's responsible for building relationships with government at all levels, as well as surveying external policy environments and adopting and developing advocacy positions for the industry. Stuart represents the APA on the Australian Attorney General's Copyright and AI Reference Group and Steering Committee. And from Aotearoa, New Zealand, we have Sam Irvine, the CEO of Copyright Licensing New Zealand and CEO of Resale Royalties Aotearoa. CLNZ is the reproduction rights organisation in New Zealand for text-based copyright material and a member of IFRO, the International Federation of Reproduction Rights Organisations. Prior to his role at CLNZ, Sam worked in communications and media sector, including in digital TV and radio. So before I hand over to Peter to start us off, I remind you that we don't have much time today to provide a full introduction to copyright law or an explainer of generative AI technologies. However, if you are interested to learn more about these topics, webinar recordings are available on the ALPSP website, and I highly recommend the Copyright Agency's webinar with Dr. Rob Nichols from August this year, which is available on the agency website and on their YouTube channel. So I'll now hand over to our first speaker, Peter Schopert in Singapore. Good morning, Peter.
Good morning, Alex, and thanks so much for the invitation and great audience we have here. Very happy to share Singapore's developments in Singapore's copyright law. I guess I was speaking at the STM conference before Frankfurt this year and was introduced as the Singapore is the bad boy of copyright exceptions. But let me give you some nuance around that characterization. and talk to you about our TDM exception and recent development. So I will just share the screen here. And okay. Hope you guys are seeing that. Let me just get over
All
to
good.
it. Okay, super. So I'll talk a little bit about the Singapore exception, its background when it came into force, and the key question: does the Singapore TDM or computational data analysis exception allow pre-training of large language models? Yes or no? And then we'll look at a recent development in April 2024, a fresh consultation, and then conclude with a few remarks on the implications of all of this. So the Singapore exception, like the EU text and data mining exception under the Digital Single Market Initiative, had its roots in a sort of 2015, 2016 version of machine learning. And Singapore established a national AI strategy in 2016, and updating the law was seen as part of that strategy. There were many other overdue updates in the language of the law as well. So that idea to change to introduce the exception was really based on traditional machine learning. Certainly in the eyes of the lawmakers, they were looking at examples from traditional machine learning, which is supervised learning. So where you give the model very carefully curated tables of data, highly groomed. And sometimes that data is, you've extracted it from text. So you've extracted chemical compounds from journal articles or something. And so that kind of machine learning was the old machine learning, where you're actually pulling facts, you're mining data from texts. But of course, 2021, 2022, when these laws came into force, we have a very different kind of AI. We have large language models, which are based on unsupervised learning from huge amounts of text, where you don't need to do all of that curation. So the laws are actually written in very different contexts. Well, we fought, the Singapore Book Publishers Association, which I was president of at the time, fought pretty hard on this, but to be frank, we had a little trouble getting excitement from some of our members and some of our communities. It all seemed a bit technical and remote, text and data mining. We did succeed, I think, in influencing the law in important ways. But we did not win on the exception. One of the folks who was driving this process in the Singapore government side later said, when recalling the process, well, the publishers weren't happy, but Singapore had aspirations to be a data hub, so we went ahead. Other countries will make other choices. I can't name the person since it was said under Chatham House rules, but that's kind of looking back from the Singapore policymaker perspective. So we were heard, but on balance, our voice was not deemed to be important enough. I brought Jose Borguinho, the Secretary General of the International Publishers Association and an Australian, of course, to see our head copyright person at the Intellectual Property Office of Singapore. And he said, oh, congratulations on giving Google everything they asked for. And she objected to that. She said, oh, no, actually, we weren't thinking of Google at all. This was our Smart Nation strategy exception. So the Singapore explanation for this was that it was really about allowing the country and the government to use new technologies. And the examples that they gave, the use cases that they gave the time they're working on the law, were all about trawling social media in order to do sentiment analysis and that sort of thing. She did also add, though, oh, but Google did thank us. So the law came into force on November 21st, 2021. What is covered in the law? It's not text and data mining in the language of the EU exception. It's computational data analysis, using a computer program to identify, extract, and analyze information or data from the work or recording. So that's the purpose. And of course, at the face of it, generative AI is doing other things. Although you could argue that it starts with this process, but the end of what generative AI is doing is something entirely different. It is not analyzing information, it's creating new output, which is very similar to the inputs. So that's what it's covered. And so that's one thing to think about when we ask ourselves if the exception covers large language model training. And under what conditions is copying allowed? Well, for this purpose, computational data analysis only, or the verification and study of that analysis. The copy cannot be used for any other purpose. The copier must have lawful access to the material. Lawful access, not exactly defined, but this, we were told over and over again, is a key aspect of the law. And the copy cannot be an infringing copy. So even if you have legal access to it, I mean, it's on the internet, say, if it's an infringing copy, it's not allowed. Although there is a big backdoor here to excuse people who can't be expected to know, couldn't be expected to know that the original copy was infringing. So, of course, one of the things we've done is call out data sets which we know were infringing. So that's the other key part of the exception, and the one that's quite difficult, is that there is a contract override. So you're not free to override this exception in your contract or your terms of use. And so that gives publishers less room. Now, our contract does give us some, there's a bit of a gray area here in that you can put in toll controls and access controls to limit the amount of copying that's done, but you can't block the copying completely under the terms of the contract override. So does this cover LLM training? Well, the initial statements from the Copyright Office sort of said yes. But then Singapore's top legal scholars in papers and opinions in the newspaper said, well, actually, no, it doesn't, for various reasons, including Berne and including the definition of computational data analysis. A paper written by senior IPOS figures late last year, about a year ago, but in their personal capacity, argued that it probably does. So basically, we don't really have, and if you ask the copyright officials directly, they will say there is not perfect certainty here. I can tell you that it is not preventing licensing from happening. When either for pre-training or for retrieval augmented generation, RAG, and other sorts of purposes. And the government agency, which is training local model, on local content and Singlish and so on, they have suggested that they think compensation is important. They haven't made any offers yet, and it's not clear how their efforts will proceed. But I think they certainly are not proceeding on the basis that, well, the law allows us to copy anything we have legal access to. But I should remind you that the exception is not the only story. There is also a fair use exception in Singapore. And under the 2021 Act, defenses are, if you want to defend copying, you can use both defenses at the same time, one after the other. So the answer is maybe. And so we don't quite have the perfect legal certainty that you might be told Singapore does give AI trainers. It's certainly not the case that it's certain. Now in 2024, we got a bit of a curveball that we weren't expecting, in that there is a public consultation on exceptions to the regulations. This is a little bit in the weeds, and forgive me, and please ask questions if I am not super clear on this. But there's a review of regulations that comes every 3 years as part of the rules adopted after we signed an FTA with the US. And it asks if there should be exceptions to circumvention sanctions. So that means, there's an exception to allow overcoming DRM for the purposes of making a copy for under Marrakesh Treaty, for example. So if you have to break DRM to do that, it could be okay. So there is an exception to TPM circumvention, usually very, very limited, you know. But they introduced the question, should we allow this kind of exception to circumvention sanctions to allow copying under the computational data analysis? So we're like, whoa, that's completely crazy because that's so out of sync with the legal access. So you're basically saying, oh, is it okay? We allow you to circumvent the guarantee of legal access, which is, you know, paywalls and so on. So there are two interpretations as to why this consultation was extended to the exception. One, there are people who really say we need more certainty. So if we can push this through, there will be more certainty that, hey, you are allowed to train all kinds of models on content. But I think that's the minority view, but certainly we have to be alive to that possibility. The majority view is that, well, the law calls for reviews of sanctions against all the exceptions, and therefore we should ask for views on this. So, of course, publishers and our class, our RRO here in Singapore for Print Matters, we gave very strong feedback. We got feedback from many other groups, international groups as well. I don't think we're going to hear anything soon. My sense is that Singapore, even as it's introducing its national AI strategy here, as you see it all in one slide, my sense is that Singapore does not want to be out in front too far. So they're in a position where they're projecting a friendly environment for AI investment, and indeed OpenAI has just announced a Singapore office. But they're also want to be seen as a responsible regulator. And that is here in the slide, I think in the lower, your lower right. And so for Singapore to be way out in front on copyright, I think doesn't fit that. So my guess is that they are vamping a little bit, playing for time, seeing how the debate evolves. I could be wrong, however. Singapore did recently announce that it had stopped building new data centers because otherwise it said it would be difficult to meet Singapore's carbon emissions targets. And then earlier this year, they've said, well, actually, we need more data centers. And we'll have even more if we can make them greener. So we're still in a very, in a situation where tech is, you know, bringing in millions of dollars of investment. Billions of dollars of investment over a long time period. And we still have the most liberal exception in the world, but it doesn't give that much comfort to LLM training. So the matter is hardly settled. Watch this space. Thanks for your help, support, and interest. And it continues to be a good place to do business and to do publishing from. Thanks.
Thank you, Peter. And thanks for explaining what I think is often quite a misunderstood and perhaps misreported aspects of copyright law in Singapore. So we really appreciate that clarity. And also highlighting the lack of clarity that a right. Seemingly liberal copyright regulation brings doesn't always bring the certainty to either side of the debate. So thanks for highlighting that.
Certainty is a scarce resource I'm coming to understand in copyright discussion.
It sure is, and in other places too, I think. Thank you, Peter. Our next speaker is Dr. Stuart Glover, who's going to be speaking to us from Australia. Here's Stuart. I don't think Stuart's showing slides, so I'll let you get started, Stuart. Thank you so much.
Thanks very much, Alex. Thanks for that, Peter. That was great. I'm coming as well from Melbourne or Naarm and give my due acknowledgements to the Kulin Nation. I work for the Australian Publishers Association, so we're a 200-member association across trade, education, scholarly and journals, and that's been reflected in the AI advocacy that we've been doing over the last two years or so. It's fair to say that AI has been the most important advocacy issue, and AI and copyright the most important advocacy issue for the publishing industry over that period of time. And we, as Joe flagged at the very beginning, the messaging has been both about opportunity and risk. We've tried to represent both those things. In some sense, Australia was a little bit slow to the policy process in relation to AI. There were some long-standing frameworks to do with ethical use of computational capacity that had come out of the science portfolios and the specialist science institutions going back more than half a decade. But in some sense, as a policy concern, it didn't get any speed up until there was the sudden burst of public interest in generative AI going back a couple of years. The developments in terms of the copyright law and AI in Australia are in an interesting relationship to then the wider government treatment of AI policy. So the overall lead minister in relation to AI policy development is actually the Industry and Science Minister, a guy called Ed Husic. And he has overseen now two significant reports on what's called the safe and responsible use of AI. An initial report at the beginning of this year, and then in about 2 months ago, he introduced a proposal for the introduction of mandatory guardrails for AI in high-risk settings. So those high-risk settings are things like the safety of children, but there is an interesting flagging of generative, the generative AI, the large language models, for example, as a high-risk setting. But it didn't flag anything specific to do with, say, the copyright industries, who've obviously had issues to do with the ingestion of their materials, or the broader knowledge economy as high-risk settings. So all of the subsequent policy making in other fields are happening with that kind of guardrail mechanism in the background. And there is an absolute waterfall of consultation and policy thinking happening about AI in Australia. So we've been completely locked up with consultations about AI in education, some of which has had things to do with copyright, particularly around possible arguments from educationalists about exceptions to the educational statutory license for the use of AI, but also state government consultations. At the moment, there's consumer law consultations, there's social media consultations, and part of the interesting context in Australia is a kind of general anxiety, I guess, about the role of big tech and platforms in our lives and industry sectors, which is beginning to flavour the conversations that we're having. And in fact, the most interesting public conversation about this that's happened in terms of AIs. One is Books 3, which I'll talk about in a second, but also a Senate inquiry into AI, which is quite broad ranging. It's considering issues like AI and democracy, but there was a specific testimony demanded of some of the big tech companies. So Google and Amazon were quizzed on the record about their data ingestion practices, things like whether the Google Books or the Amazon e-books holdings were used in the training of AI, and no clear answer was provided to those questions. So there is quite a lot of heat and interest around these questions at the moment in Australia. But as Joe flagged and Alex flagged, there is a specific process being pursued in relation to copyright protections in the AI context. And the APA, along with other creative sectors, is part of a body called the Copyright and AI Reference Group, and which has been established by the Attorney General. The current government has taken a kind of consensus-based approach to the development of copyright law, not just on AI, but also other issues and other kinds of exceptions that are being sought by libraries and other users at the moment. And that gave rise to the establishment of this reference group at the end of last year. It's got about 60 entities on it, 25 or so from the creative industries, but also representation from tech and from user groups. Its work to date has been to conduct a survey of industry inputs. So from our point of view, that was gathering information from publishing houses about the kinds of deals that they are doing or expecting to do with AI companies to participate in direct licensing deals. Now, that obviously, in many ways, brought sort of scientific and scholarly publishers to the fore, because their materials have a particular kind of value in the AI economy, and they provided some information about that. The CARE group also has established a bureaucratic team to lead policy work, and we're expecting that the focus of their work over the next 6 to 12 months will be around transparency, remuneration, around cultural protections, and around user permissions. And we expect that in the 6 to 12 month timeframe, that we'll get some kind of proposals from government about copyright and AI. This is complicated by the imminence of a new federal election in Australia before May next year. And we don't know whether the opposition, who have some prospect of being elected, will what position that they will take on copyright and AI, or copyright more generally. A couple of years ago, they tried to introduce a relatively hostile act to the Australian copyright protections. So we, at the moment, in terms of this KEG process, we have some concerns about the effectiveness of it as a mechanism. The tech sector, which obviously knows how their black box works and knows what's been ingested, have been a little bit reluctant to share information. And to, in some sense, the government has placed, the KEG process has placed a ring fence around consideration of the international copyright dimensions that are in play here. So in that framework, what the APA has been advocating for is obviously continuation of what Joe flagged is Australia's robust copyright framework, including pushing back on the idea that there's any kind of significant uncertainty around the status of training and the status of outputs. We've been advocating for some kind of standalone transparency legislation that probably would fall outside the copyright framework, potentially within competition and consumer law. We've been opposing the kind of broad exception for a text and data mining exception that Peter's been facing. We've instead been advocating for kind of licensing solutions, particularly in education settings, both direct licensing solutions and also collective licensing solutions. There has been, in some sense, the advocacy in Australia has been driven more by the trade publishers than by the education and scholarly publishers, the public advocacy. And there's been an expression of the frustration over the massive unauthorized data ingestion by AI and advocacy for some kind of remuneration. There has been, however, and this is something the APA we've tried to highlight, are the threats to the integrity of information and the integrity of published scientific research. That's not at the very center of a copyright-focused discussion, but it is one way that we've used. It's one way that we've caught the attention of the science minister, who's been otherwise not very concerned with the copyright issues. So there are a number of tricky issues that are impacting the process. So obviously Australia has been slow out of the blocks. We've had challenges in the collection of evidence about the ingestion and about the workings of the large language models. There are complexities in the pathways to the development of licenses. So obviously within the industry itself, as industry is beginning to take up and develop, offer direct licenses, there are a variety of approaches in terms of opt-out, opt-in, and no opt-out and no opt-in arrangements, and different kinds of remuneration structures are being taken up by publishers, and that has complicated some of our advocacy with our stakeholders, fellow stakeholders across the creative industries. There's been a great deal of variety in the take-up of AI in the publishing sector in Australia. So obviously it's focused among scholarly publishers, and where it's and to a certain extent educational publishers, and where it's used in trade, there's kind of greater antipathy to AI in trade, but it's obviously beginning to find use in translations and audio issues. We've got a little bit of silence in Australia from key ministers. So, for example, one of the key organising pieces of policy in Australia at the moment in the cultural policy space was the release of a new national cultural policy, which made very promising statements about the importance of robust copyright and the rights of creators. But noticeably, the Arts Minister hasn't had much to say about AI. And I would finish by saying that the other concern is a little bit about a marginalisation of the discussion about the issues of truth and data reliability. So there's that's getting a little bit of a run in policy discussions about misinformation and with social media, but much less of a run in relation to the maintaining of the scientific record. But that's an issue we continue to push. So I might just leave it there.
Thanks, Stuart. As you say, Australia was a bit behind the 8 ball, but we've come out in a flurry of those consultations in all sorts of areas. So those of us in the Australian publishing community are very grateful to your work at the APA for staying across that and keeping the voice loud and consistent in those myriad of consultations and approaches. So thank you very much.
Thanks, Alex.
Our next speaker is Sam Irvine, who is over in New Zealand. Good afternoon, Sam. We're really looking forward to hearing about developments over your way.
Hello, Alex. Thank you. Thank you for having me, and thanks to Stuart and Peter for their very thorough examinations of what's happening within AI regulation and policy within their jurisdictions. And I guess it's fair to say if Australia is slow, then New Zealand's probably slower, or is slower. And I guess we're in a period of extended consultation. Well, as with a lot of things we do within the South Pacific, we will probably take a lot of what we do from our big cousins here over there in Australia. So I'll just share my screen, and I know some of you will have some good questions. So I'll keep this reasonably brief, which also probably reflects, I guess, some of the lack of progress we have here in Aotearoa, New Zealand. So just in terms of, go to the next slide. In terms of regulation, yeah, as I said, we don't currently have any direct AI regulation, and I guess that sort of refers to the fact that where it is at the moment is that it's focusing more on safety and privacy. And the Privacy Act does give us some protection, as in publishers and authors, in terms of AI. And I would just say that Copyright Licensing New Zealand is jointly owned by the Publishers Association of New Zealand and also by the New Zealand Society of Authors. So we do take, I guess, our recommendations on behalf of those two through into regulation policy and consultation processes. Interestingly, we also on December the 1st will be helping the government of New Zealand launch artist resale royalty for the first time in Aotearoa. So we're managing that rollout of that process. So that will bring in another area of AI and copyright concerns into what we look at in terms of the jurisdiction. So yes, the Privacy Act is seen as applying to AI systems in New Zealand, and I'll talk to that a little bit in the next slide. What I want to talk to you about is about regulation, policy, and then consultation. So there'll just be those three areas. We do or may have a Copyright Act review coming up in the near future. One of our, or certainly our initial briefings into ministers of the new incoming government last year, in 2023, was about the importance of including AI within the consideration within the Copyright Act review. And I'm pleased to say that we seem to have got some traction with that viewpoint within the review document or the review discussions we've had with the ministers involved more recently. We do have a special consideration in New Zealand, Aotearoa, around the Treaty of Waitangi and what is referred to as the Y262 claim. The Y262 claim was raised in 1991, and in 2011 there was a report, Ko Aotearoa Tēnei, which was the Waitangi Tribunal, who the claims go to, their report regarding Y262. Perhaps I talk a little bit about Y262 now, which is it's really a claim that came about where it was asking the government and the state to provide recognition and protection of Māori rights for intellectual property, cultural practices, and Indigenous flora and fauna. And it's an interesting and very wide-ranging claim, obviously, but it does have significant consideration, for example, with Te Reo Māori, so the Māori language, and how that is interpreted within training data. So who provides that data, and how is it policed in terms of its veracity around the Māori language? So I think there's some very interesting developments to come around the Y262 claim. In terms of current policy work, the Privacy Commissioner has issued guidance around compliance in terms of privacy law. It's all the usual things around data collection, consent and transparency, data minimization, right of access to correct and also be able to delete personal data, which is, of course, pretty complex when you're talking about data that's embedded in training models or used in automated decision making. So, from a publishing context, we've already seen some of the challenges globally around when people's work has been ingested into training data and large language models. Offshore data transfer regulations are of real interest too, and may form some of the discussion that we have in terms of the Copyright Act review around levies and other considerations when we look at large language models that are sourced out of foreign jurisdictions. In terms of consultation, we have a large group. It's nothing like the well, it is a little bit like the reference group within Australia, but they came out with a blueprint. I'm on that. There are representatives from the creative industry, and it does have a specific creative industry recommendation. And I guess its core purpose is to help update the IP regulations, as that statement says here, to provide dynamic protection and clarify usage, including AI whakapapa provenance, which comes back to the Y262 claim. There is a piece in there around identifying and I guess regulating the use of content sourced within New Zealand for large language models. The actual technical capability to do that probably does exist. The appetite to do it possibly doesn't exist. So I think that's going to be one of the areas that as a group within this AI forum, the creative group will focus on in the next short term. Amplify just came out last week, and this is from our new Minister of Culture and Heritage, and it's a cultural strategy for New Zealand. We've never actually had one, so I think full marks to Minister Goldsmith and his office for delivering this document. It's a draft, and there's a consultation process, quite short, I would add. We have until the 15th of December to provide a submission to this. And it does include considerations around IP and not specifically talking to copyright, but certainly the tone of the document would say that we have certainly some good opportunity there to provide a submission around the importance of the respect of copyright, so in terms of acknowledgement, remuneration, or permission, acknowledgement and remuneration for the use of publishers' work within large language models and within prompt data as well. So yeah, that's something that we are looking forward to being involved in, and looking forward to that informing further work around the Copyright Act review within the next 12 to 18 months. I think probably I can leave it there and perhaps go back to you, Alex, to take some questions.
Yeah, thank you, Sam. And thanks for walking us through that. What struck me in all of these presentations is the variety of sort of routes of entry to these issues in the different countries that we've been representing and discussing today. There's just such a myriad of sort of spot fires to watch, you know, as we're trying to keep track of all this. And I think in New Zealand too, there is such, you know, similar to Australia, sort of particular cultural and historical matters that get brought into this in ways that perhaps were initially unexpected, and how we have to keep those at sort of the forefront of our minds as well. So it's been great to have the three speakers give us those sort of comparative examples of the approaches being taken in the different countries we've had represented today. I am going to open up for questions now, as Sam mentioned. I will just put some information on screen about our speakers, because I'm asking you to please put your questions in the chat function in Teams. And when you do that, it would also be really helpful if you could provide the name of the speaker that you're directing your question to. So if you could please do that in the chat function, and I'll wait for those to come through. As they're coming through, I was going to offer Jo Johnson, as our host and sponsor today, the opportunity to open up with some questions that I'm sure Jo has for some of our speakers.
Thank you, Alex. That was a fantastic discussion, everyone. Thank you very much. Look, as an avid reader of Peter's blog, I was delighted to see he posted again recently, including introducing me to the hyperscaler, which I'm going to adopt myself now, with full acknowledgement, of course. And Peter, I was just wondering whether you could do, for the benefit of everyone here, a very quick summary of the hypothesis in that blog, that perhaps all where the different roads are leading us to, whether it be the EU TDM with an opt-out, the Japanese, Singapore, more permissive models, or the US on their track with fair use as a defense.
Thanks, Jo. Yeah, I did have a little bit of writer's remorse after pressing send on that, because it's a little rash, I think. But in the interest of moving the conversation forward, and in full acknowledgement that, you know, I really only have a partial picture, I think I'll answer that question by saying I do think the European, I do think there's a Brussels effect. Because even if Singapore and Japan are still not giving great certainty and are still needing to be sorted through, the US is caught up in court, and, you know, the fair use cases have all very different paths, and so many, they're all based on facts of the particular matter under discussion and so on. So it could take a long time for that to sort out. I mean, a new factor is, of course, that the US might be positioned to actually make legislation again, unfortunately, probably driven by the interests of some of the hyperscalers who supported the Trump campaign. But despite that, I think the fact the Europeans have a law, and the European law says if you want to scale out your models in Europe, you have to obey European law. And we've all, thought about our privacy policies in line with the European GDPR. So I think that effect is real. And I think it's probably a good idea for copyright holders around the world to reserve their rights using the mechanisms that the European publishers have come up with to reserve rights under European law. So to repeat, the European law is text and data mining is allowed for commercial purposes, but only if copyright holders have not said, hey, hold it, we reserve our rights. So, it's not a perfect situation from a copyright law perspective. We don't need to reserve our rights. Copyright's an inherent right, but still that's the system that they have. And I think it behooves all of us to reserve our rights using the mechanisms that the European publishers have come up with. It seems to be a total no regrets move. So yeah, so that's my view. I think the licensing is happening. I mean, thanks to the good work of the RROs, thanks to publishers making licensing deals, and I hope not excusing the training that was done before the deal, because that would certainly, I think, be any agreement that did that would be a bad agreement. But so licensing is happening, and the European law is giving a framework for more licensing and compelling AI companies to comply with that law if they want to roll out their models. And of course, they're saying, well, we won't roll out our models in Europe, but that seems to me the usual sort of bluff that you get in these discussions. So yeah, sorry to ramble on a bit, but I hope that answers the question.
It's a good point to end on, Peter, too, because I think obviously they'll go where the market is. So if there's a market, they will go there if that's where they want to be. And I think something perhaps is more challenging for the countries that we've been discussing today is that we are a much smaller market. And I think this tends to then impact what ability we have to sort of put up our particular preferences and to lobby and develop the laws as we would wish, given our size. And I think that probably brings me on to the next question too, which is for Sam. We've got a question here, Sam, which is about where is the pressure for change and regulation coming from in New Zealand? Is it a sense of sort of keeping up with everyone else, or are local businesses and industries sort of actively seeking clarity?
Yeah, it's a good question, because I think, as in most countries, there is a pressure. They're diametrically opposed. So rights holders would like clarity around copyright, so permission, remuneration, both locally and overseas models. And then there's also the users of AI who say, well, this is all, it's happening, so why do we need any regulation? It seems fine at the moment. So I think, and there's two phrases I like to use and seem to have gained some traction, which is you can be pro-copyright and pro-AI. And certainly that's what we've been very conscious of ensuring as part of our messaging into both officials and into the ministry itself. And the second one is that collective licensing is a solution to responsible AI. So collective licensing by its nature includes permission and acknowledgement and remuneration. So there is a ready-made solution, if you like, and how we enact that, I think globally is a really good question, because if we're all on the same page globally, then it'll make it a lot easier for us to enact those local regulations to make it happen.
Yeah, I think that's true. Aligning globally, and even to the extent that regional alignments support one another too, Sam, I think is going to be really key, isn't it? We've got a question now for Stuart. Are there any thoughts as to copyright ownership of AI platform output, or is the general consensus that copyright protection does not exist on the output in Australia, because the Australian Copyright Act has not yet addressed the notion of protection of something not created by a human. Now, this question is not limited to Australia, but Stuart, could you give us any insight to whether this has been a key issue in the discussions that you've been having?
I'd almost defer to Joe on this, but my understanding is that the copyright doesn't extend to outputs that are created with AI. That's a pretty widely accepted position in Australia, although the tech sector has suggested there is some uncertainty. I think one of the interesting things that's beginning to happen across the creative industries as they're beginning to engage with AI as creators and as publishers and filmmakers is clarity around transparency of AI use on the creation of those outputs and different imperatives. For example, filmmakers wanting to avoid a situation where there's some kind of imprint on the screen which gets in the way of viewing that signals that something has been created with AI. So there are emerging conversations about outputs, but I think, and I'm looking at Joe, that there's clarity under the law.
Can I just jump in there then, Alex, since
yes, Joe, please.
Stuart suggested. Our position has been that Australian law is not uncertain and it's not unclear on this. We don't have a copyright registration system like there is in the US. Copyright just subsists if it satisfies the criteria, and the criteria does require a degree of human creativity and the involvement with the creation of the works. So that's a question of degree. Australian law is well understood in that respect, and we say there's no uncertainty that requires clarification there.
Thank you, Joe. Yeah, and Peter, I don't know if you've got anything to add from the Singapore perspective, whether this question's come up in similar discussions there.
I don't think it's a major issue here in Singapore, but I think it was sort of an issue early on in the discussion when we first looked at generative AI, faded a bit, but I think it will come back, especially as many businesses, including some publishers, will want to seek protection for work that they've created that does have AI input. So it's definitely coming back, and whether we'll see a sui generis right discussed or not, I think we will probably see that discussed as well. So I think it's worth, even though the law is clear, I agree with Joe, the fact that there is a continuum of different ways of working with the AI between creation and generation. I think it does behoove us to think a little bit about this in advance of the public debate.
Yeah, for the consultations to come, no doubt. Well, we've hit time, so I will wrap things up, but a very big thank you for everyone attending today, for your questions, to our terrific speakers, and of course to our sponsor, the Copyright Agency, to Jo Johnson and also her team, Lydia Spooner and Nick Keverick, for getting this all set up for us today. Really appreciate it. Please stay in touch with the ALPSP for future webinars on this subject and many other topics, as you can see on the screen, lots of other scholarly knowledge sharing. Thank you so much, everyone, and have a very good afternoon or evening.